Hi, everyone. Welcome to ComACL Carey's webinar on developments in the retaliation and whistleblower landscape. My name is Lindsay DeSalvo, and I will be one of the presenters today. I have quite a bit of experience with this particular topic. I handle a lot of whistleblower and retaliation cases for employers in representation, particularly in an agency setting, as well as in the federal court, state courts. Work with employers a lot on development of position statements, communications with the agency investigator, strategy for responses throughout the investigation process. So I'm looking forward to going through some of that knowledge and experience with you all today, and I'll turn it briefly over to my colleague Mark Ishu to introduce himself as well.
Thank you, Lindsay. My name is Mark Ishu. I just before joining ConMas Healthcare about over 2 years ago, I served over a decade as a trial attorney at the U.S. Department of Labor, Office of the Solicitor. Before that, I was at the Illinois Attorney General. I represented mainly the Illinois Department of Labor. My whole career, I've been focusing on workplace safety, and I've been advising clients on how to proactively address labor and employment concerns, including whistleblower cases, both advising the Department of Labor investigators back when I was at the department, as well as here at ConMyCL representing the private sector.
Here's a layout of our agenda for today and all the topics that we hope to cover, and we'll try to move briskly through to make sure that we get them all covered today. The first is we'll do a quick review of major anti-retaliation and whistleblower protections. Particularly, we're going to be focusing today on the EEOC and retaliation claims investigated by the EEOC, as well as the whistleblower claims that are investigated by OSHA. And Mark will talk a little bit about this as we go into the presentation, but OSHA actually investigates several whistleblower provisions outside of just the OSH Act. So we'll talk a little bit about that as well. We'll also spend some time reviewing charges and burdens of proof / the enforcement process. I think this topic is particularly important in considering how to respond when you receive a whistleblower complaint, what the investigator is going to be looking for, and getting a good understanding of that. So we'll spend some time on that today. How the federal agencies are currently approaching enforcement, and particularly how they're working together on enforcement matters. And then finally, we'll close out with some recommendations to avoid this whole process, hopefully. Things that employers can do, steps they can take to try to address complaints and concerns in-house, and set themselves up to address those effectively, so there isn't necessarily a need for employees to go to these agencies with their complaints and concerns. So with that, I will turn it over to Mark to start us off.
Thank you, Lindsay. So federal law offers, a robust protection to employees who raise concerns about workplace safety conditions or discrimination. These protections come from several statutes, such as the Title VII American Disability Act and the OSH Act. Our focus is going to be to try to understand how these protections are triggered and enforced, and again, give you some tips and pointers to help you along the way. So the EEOC is the first topic we want to focus on. It has a very robust set of anti-retaliation laws. When an employee files a charge, say under either the ADA or Title VII, they're protected from any adverse actions their employer might take in response. That may be something smaller, but something bigger. There's a lot of case law that talks about what type of actions could be considered retaliation. We can't go into all the details today, but I just want you to be aware that the treatment of that employee is very, very critical after filing a EEOC case. Timeframes are strict, and we're going to go into this in detail, but it's usually 180 days to file a case, or some states have extended it to the 300 days, and that would be in the EEOC. So, like I said, we have a time frame that we have to file. The complainant has to file the case, otherwise it's time barred. But I want to point out that several states have changed kind of the way they're looking at the time frames, or they want to extend more kind of concessions to employees. to be able to file a case. And I'm in Illinois, and I just want to give you that example. In January 1st, 2025, the deadline for filing an administrative charge with the Illinois Department of Human Rights, which is the EEOC equivalent within Illinois, based on employment discrimination, harassment, or retaliation, was formerly 300 days. So you could file either in either forum, the EEOC or the IDHR. But now you could also file in the IDHR after your deadline for filing a claim in the EEOC has expired. It's extended now in Illinois to 2 years after the date that a civil rights violation allegedly had been committed. So Illinois is now one of the largest, or excuse me, the longest statute of limitations, has one of the longest statute of limitations for state employment discrimination laws. And most states, I want to point out, are 180 or 300 days. So just keep that in mind. I want to highlight some states that are not that are similar to Illinois, and they've extended it, but they have various timeframes. So you have to look up the timeframes. But Arkansas, California, the District of Columbia, Florida, Idaho, Minnesota, New York, Ohio, Oregon, Rhode Island, Vermont, West Virginia, and as I said, Illinois have now extended the trend, or have kind of joined the growing trend to extend these deadlines well beyond the federal requirement. Now, after a charge is filed, the EEOC may investigate, issue findings, and potentially litigate or authorize the individual to file in federal court. After 180 days, the complaint can request a right to sue letter. So that's 180 days once they file. And that right to sue letter would allow them to go to federal court and bring their claim, and fully litigate their claim there. The legal burden, and we're going to talk a lot about that. Lindsay's going to talk a lot about that in the next segment of slides. Shows basically that there was a protected activity that led to an adverse treatment. So you have, either filing an EEOC case, and then something you do to the employee specifically is considered retaliation, and that obviously would lead to adverse treatment and justify a retaliation case in the EEOC. This slide, we wanted to show you some, how prevalent EEOC retaliation claims are filed, versus other types of cases or discrimination cases. We have here kind of highlighted kind of the trend and, the years. And, although there's been a dip under Title VII retaliation from 2023 to 2024, it's likely going to increase the next year. But all the statutes, as you can see, are significantly, there's significant filings. The amount of filings is well beyond any of the other statutes. So now we're going to switch gears to talk about OSHA whistleblower retaliation. OSHA enforces whistleblower provisions under 22 statutes. These include, but are not limited to, environmental laws, several environmental laws, this Sarbanes-Oxley Act, and then Affordable Care Act. The most commonly used authority to issue a retaliation complaint or to file under is Section 11C of the Occupational Safety and Health Act. So understanding OSHA's role in this context is very important, and it's something that you're going to have to be familiar with, even though you focus only on safety and health, because a lot of these types of cases, if you start with an OSHA inspection, there's someone cooperating in that OSHA inspection, and then later on ends up getting either fired for something totally unrelated and totally justified. Well, they're going to have a chance to file an EEOC case, and there may be a strong basis for that case to be take a lot of resources out of you and your staff to make sure that it's established, that the case is established in a way where there isn't a finding by OSHA that there's any retaliation. So it's very important to be aware that 11C of the OSH Act is parallels any OSHA investigation. So at CMC, we always like to give you kind of trends to see what the data shows as to how important these issues are, so that you could adjust your practice and your organization to better fit what the priorities are. Here, you could see that the OSH Act is about 71% of all whistleblower claims enforced by OSHA. There's, again, several other whistleblower statutes that OSHA enforces, but the OSH Act is pretty much the number one. And, that's good and bad for several reasons, as we're going to get into for your sake. But one of the things that I think is important to note immediately is that the OSH Act, 11C Act, has a very strict timeline, one of the most rigid timelines on when an employee could file a retaliation claim. So according to, just let me just be clear. A lot of this stuff you could find out online. It's within the statute, the OSH Act, but a lot of it's listed online. The Department of Labor does a great job in laying out all the different statutes, and specifically gives you kind of details as to how they enforce those statutes. So there's a chart online that you could go to, but we've kind of summarized some of it here. And so it says here, as you can see, the 30 days for the OSH Act 11C, MSHA, or Mine Safety and Health Act, retaliation is 60 days. There's several small nuanced statutes that are also 30 days. But you could see, there's some that are also 180 days. STA is a very Surface Transportation Act. That's a very commonly filed claim as well, but not as much as the OSH Act, and that's 180 days. Sarbanes-Oxley, 180 days. Pipeline safety, 180 days. So just keep that in mind, and don't just think it's one statute of limitations when it comes to whistleblower statutes. So let's talk about the process of the whistleblower complaint. Once a complaint is filed, OSHA will evaluate whether there's a reasonable cause to believe retaliation occurred. Reasonable cause is different than the standard that would need to be established to actually win a case in federal court. It's not the standard. It's just a threshold, nuanced standard to help the OSHA investigation kind of evolve to being much more seriously taken in consideration before filing a case in federal court. One of the things that's very important here to understand is, and kind of what I was trying to mention earlier, that's it's kind of good for employers, is that if the Department of Labor does not find a 11C violation, then there is no private right of action for the complainant. There is no action for the complainant. And so that, the case is dead. So if you could convince that OSHA investigator to not investigate or even, pursue once it's investigated the case, then you have then the case is done. Now, other whistleblower statutes, if the Department of Labor finds that, for example, under STA, if the Department of Labor finds that there is no violation, they give the individual complainant the right to still file in the Office of Administrative Law Judge a complaint for retaliation within a period of time that each statute allows. And that gives them another bite at the apple, essentially. And then they could go through that litigation process, and then they could probably remove that case if it's a decision's not made within another 180 days to federal court. So things linger much more with these other statutes. So the OSH Act, the good news with the OSH Act and 11C specifically is there's no private right of action. But again, when the department looks at it first, they look at the reasonable cause standard versus what would need to be proven in court. So the standard is much lower than what's needed in court. And so you need to get your evidence ready right away to be able to establish a good, strong basis to not waste, to show that the Department of Labor shouldn't want to waste its time on the case. That's the best kind of advice I could give you from being internal, because there's limited resources. And so they have to prioritize their cases. And federal court litigation is very serious once they start getting their lawyers involved, like what I used to be in terms of advising. So that's an overview of the process. And now I'm going to turn it to Lindsay to talk more about what a charge is and the burdens of proof.
So we'll spend a little time now reviewing sort of the standard that's used in evaluating these claims. What is the agency looking for? What are they evaluating to determine whether that reasonable cause standard can be met by the complainant? This slide shows a general overview of how that investigation process works. It starts when the complaint or the charge from the EEOC perspective is filed with the appropriate agency. The agency will then notify the employer and request a response. And this is sort of, again, we're talking about this generally from the EEOC investigation perspective, the OSHA perspective, and that's the general process is they'll get the complaint from the complainant or the charging party, and then they will notify the employer and give them an opportunity to respond. And generally, what they're looking for in that response is that the employer submit what we term and what they also refer to as a position statement. And that is a document that you put together where you're laying out your positions as to why this complaint is insufficient, why it doesn't meet some standard that's required for it to proceed, as well as providing supporting documentation to support all of these assertions that you're making in the position statement. The investigator will then review the complaint and the position statement, and there may be follow-up after that. If they have additional questions, they may respond with those questions and ask for that additional information from the employer. They may also want to see some additional documents. And they might want to talk to people. In the position statement, the employer may have identified a manager who's involved in the decision-making process, or the complainant in their complaint may have identified a coworker who is similarly situated to them, but was not treated in the same way. And as the investigator reviews the complaint and the position statement, they may put a list together of people that they think have relevant information, and so they'll want to talk to them in the course of the investigation. We have also had, I think, a few instances now where the investigator has asked for a supplemental response or supplemental position statement. So the employer has already provided the initial position statement, but they, as part of the investigation process, the investigator is going to go back to the charging party or the complainant and say, here is what the employer is saying. How do you respond to that? And if there is a substantive response, the investigator may go back to the employer and say, can you address these particular issues that were raised by the complainant, and ask that that be done in a supplemental position statement. Or that might be beneficial to the employer from a strategic perspective to provide a supplemental position statement to respond to those issues. So this part, I think, is really essential to the strategy of how an employer responds when they receive a complaint or a charge from an agency. And this is generally going to be the same for retaliation claims that have been filed with the EEOC, as well as whistleblower complaints that have been filed with OSHA. This slide shows what the complainant would ultimately have to prove to be able to establish a retaliation claim or a violation of the whistleblower standard. First, they have to establish that they engage in activity that is protected by the specific standard under which they're alleging the employer has violated. So in the case of Title VII, it would be activity that's protected by Title VII, like complaining about some discriminatory treatment in the work environment, or filing a complaint with the EEOC, or participating in an investigation with the EEOC. The next piece of that would be that the complainant has to be able to establish knowledge that the people who decided to take an adverse action against them, so this is closely tied with the adverse action, knew about the protected activity. If the person who ultimately made the decision to terminate the complainant, for instance, if that, is the adverse action about which they're complaining, then that person would have had to have knowledge that they filed that complaint with the EEOC. And if they don't, or the complainant can't establish that they do, then they cannot meet that element to establish their retaliation complaint. The complainant must also be able to demonstrate that they suffered some adverse action, and there is a standard for this. Not every action taken by an employer would be considered an adverse action sufficient to support a retaliation or whistleblower claim, although it is certainly a broader standard for retaliation and whistleblower complaints. Less so now, but still generally considered broader. And then finally, the complainant would have to establish a causal connection between the protected activity and the adverse employment action. And that's, again, where that knowledge element is also going to come into consideration. So first, what is considered protected activity? I addressed this a little bit in the last slide, but protected activity are going to be those actions that a complainant might have taken that would fall under the relevant statute. So again, in the context of a retaliation claim under Title VII, for instance, Title VII prohibits discrimination, for certain categories of individuals, as well as activities associated with that. So again, if the employee has made a complaint to human resources that they believe some practice at the facility is discriminatory based on sex, and then, a week later are suspended for, a particular issue, that complaint to human resources would be considered a protected activity under Title VII. From an OSHA perspective, particularly under Section 11C of the OSH Act, it would be activities associated with safety. So complaints about an unsafe work condition, or participating in an OSHA inspection or an OSHA enforcement action, providing information to an investigator. And this slide shows, I think, some additional examples of that. One that I think, is kind of different from an OSHA perspective is refusing to perform a dangerous assigned task under certain circumstances. And that would be sort of, was their position reasonable in refusing to perform that particular task based on the specific circumstances? And if it was, then that could be sufficient protected activity if there's then an adverse action taken against them at a later point. And I think the thing that we do also like to highlight here is it doesn't necessarily have to be a formal complaint. A lot of employers have and should have a process by which employees can file complaints or make complaints anonymously, various ways that they can raise concerns in a more formal matter to the employer. But if the employee can show that they went up to their manager and said, this particular machine doesn't look like it has the right guard, I'm nervous about using it, that could be sufficient to be considered protected activity under Section 11C of the OSH Act, because they did raise a concern to a manager, even though they didn't necessarily do it through the formalized complaint process. So next is employer knowledge. Again, this particular piece is being able to show that the person who actually made the decision or was involved in some way in the decision making as to the adverse action taken against the complainant, that they had knowledge of that protected activity. This is an area where, we often are able to push back in a position statement, because the ultimate decision maker, which might be human resources, and human resources is often at least involved in particularly a major decision like a suspension or termination, or, a higher level manager who might not be the one that the employee actually raised the concern to or made the complaint to that they're now claiming is their protected activity. There is often a separation between the person who might have knowledge of the alleged protected activity and the person who is ultimately making the decision as to implementing the adverse employment action. So this is an important thing to be aware of in evaluating a complaint and evaluating potential defenses to the complaint. If the decision maker is not aware of the protected activity, then they cannot, as a result, be able to establish that causal connection, because there could be no way that the protected activity played a role if that decision maker had no knowledge of it. Notably, the EEOC does consider employer knowledge, as does the Department of Labor, as its own separate element, but often it will be kind of pulled into the causal connection assessment, and we'll talk about that in a little bit more detail as well. So then next, what is an adverse action? And I think, we all sort of in this context think about things like suspensions, terminations, decreased pay, change in work hours, but it really is broader than that. There are two main elements to assessing whether something constitutes an adverse employment action. The first is that it's materially adverse. And in the context of a retaliation or whistleblower complaint, materially adverse means that it would dissuade a reasonable employee or applicant from taking that action in the future, taking the protected activity action in the future. And then the second piece there, which is sort of part of the definition of materially adverse, is a reasonable employee or applicant. So there is an objective standard here where the agency investigator and the employer, when they're evaluating a complaint, should be considering, did this adverse action or this alleged adverse action, would this have dissuaded most employees or other employees in this situation from taking that protected activity or performing that protected activity in the future. The adverse action doesn't necessarily need to be related to employment. OSHA in its whistleblower manual has a whole list of different actions that it would generally be considered adverse. I mean, they're going to consider the specific circumstances, but they lay out actions that they're generally going to consider as adverse. One of them is threats to report the individual to authorities. So that doesn't necessarily relate to their employment, but it is the type of threat that would likely impact a reasonable employee's decisions in the future as to whether they're going to take that protected activity or do that protected activity in the future. So it doesn't necessarily have to just be related to compensation or terms and conditions of employment, though that's certainly part of the assessment in determining whether it's an adverse employment action. And then the last piece here, what is a causal connection? And this standard will be a little bit different in the OSHA investigation context, depending on the particular statute under which the whistleblower complaint has been filed. And I'll talk a little bit about that. But the standard for EEOC and evaluating the statutes that they investigate for retaliation and under Section 11C of the OSH Act, the causal connection standard is, but for the protected activity, would the employer have taken the adverse employment action? And this is kind of the most employer-friendly standard of cause, because it really is fully reliant on, if they hadn't engaged in this protected activity, would the employer still have taken the adverse employment action? And that evaluation is definitely narrower than some of the other causal standards. One of the other causal standards is motivating factor, and that's sort of the broadest one, the most employee friendly, and that's going to apply to all of the environmental statutes like the Clean Water Act. A motivating factor means that the protected activity only has to be a factor in the employer's decision to take the adverse employment action, not the but for, just a factor where the motivating factor standard for cause applies. The last major standard for cause is, that is actually the contributing factor. The last major standard for cause is the motivating factor, and the motivating factor, which is again sort of not quite as broad as the contributing factor, but a little bit more narrow, or a little less narrow than the but for standard, is where the protected activity is a substantial factor in the decision to take the adverse employment action. So both the contributing factor, where the protected activity only has to be a factor in the decision, and the motivating factor, where the protected activity has to be a substantial factor in the decision. And that is the ones that are going to apply to the environmental statutes. The analysis there is not so straightforward. So the whistleblower complaints under those statutes can be a little bit more challenging from the perspective of the employer as to being able to push back on whether there is a causal connection in that case. But again, for Title VII and other statutes enforced by the EEOC, as well as 11C of the OSH Act, the but-for standard is the one that applies, and that is helpful for employers and pushing back against whether there is actually a connection between the protected activity and the adverse employment action. One of the big things that come into play in establishing a causal connection is proximity. How close in time was the adverse employment action taken after the protected activity occurred? And the closer in time that the adverse employment action happened after the protected activity, the more likely that the complainant is going to be able to establish a causal connection. There isn't really a set standard for what is sufficiently close in time to establish a causal connection. The Supreme Court has held that 3 to 4 months. So if an adverse action happens 3 to 4 months after the protected activity, that is sufficient to sort of cut that proximity tie, that's not close enough in time to establish a causal connection. But, on the other end of that means an adverse action that occurs, 2 weeks after protected activity, a month, maybe potentially even up to 2 months, could still potentially establish that causal connection. So that's a really important thing to closely assess when an employer is evaluating a complaint and evaluating their potential basis to push back on the complaint. How long since the protected activity to the adverse action do you have, and can that, kind of cut that tie of a causal connection? And this can also differ depending on, the particular courts where the individual or where the individual is working, where the facility is located. Those standards might be different. But generally, the Supreme Court has established that 3 to 4 month period as insufficient to establish a causal link. And then finally, this last piece is the employer's burden. So, all of those elements that I talked about prior, the complainant needs to establish those, but the employer can undercut the complaint by showing that they wouldn't be able to establish those elements. The legitimate non-discriminatory reason for the adverse employment action is a burden that falls on the employer to show that they had a legitimate non-discriminatory reason for taking the adverse employment action. And this slide shows just some of the more common examples we see of legitimate non-discriminatory reasons that courts have found, and the EEOC has found, and OSHA has found as legitimate non-discriminatory reasons for an adverse action. And that includes things like insubordination, repeated or excessive absences, poor performance. If the employee, has some issues with the way they're performing duties, they've been talked to about it by the employer, they've not improved, and they're terminated, that's something that can show that there was a legitimate reason for their termination. And then violations of company policies and rules is a really big one that we see too. That is a legitimate non-discriminatory reason for a disciplinary action, for instance, especially if you can point to the handbook or, a particular policy that lets the employee know, hey, if you break this rule, these are the consequences. So with that, I will turn it back over to Mark to talk about federal agency approaches to enforcement.
Thank you, Lindsay. So what are agencies doing to help coordinate themselves and be more effective in their investigations? Well, agencies like OSHA and NLRB are collaborating more than ever. We're going to go over in kind of what way they are collaborating and how they're collaborating, what to look out for. The goal, for these agencies is to present a unified front on these retaliation enforcement cases. And so, this means that you guys have to, you may have to face joint scrutiny from, overlapping investigations. And we're going to talk about how that works exactly and some tips and thoughts to help you along the way. So, memoranda of understanding, MOUs, they outline exactly how agencies share information and coordinate with each other. There are several MOUs between these agencies that we're mentioning: OSHA, EEOC, the National Labor Relations Board, and specifically within those MOUs now, they've included provisions on whistleblower referrals and how to train each each agency more effectively to be better so they could support one another. So that's something that I think has been trending. Even when I first started at the Department of Labor, probably about 2013, this is something that, or 14, this is something that they developed, and they were starting to kind of carry over more on the sharing side. But now they're coordinating much more, as you'll see with the MOU between the NLRB and OSHA. And when I say coordinating more, I mean coordinating their actual enforcement activities and their investigations. So here are some MOUs to be aware of. And we're going to go more into the MOU between the NLRB and OSHA. But please be aware that there are several others. The Department of Labor has various agencies within it, including Wage and Hour Division. There's a NLRB Wage and Hour Division Memorandum of Understanding. They share a lot of information. And there's, under the Fair Labor Standards Act, there's something called 15A3 retaliation complaint. So it's a retaliation. It's under the Fair Labor Standards Act specifically. It's a federal, it would be a federal case. Someone would have a right to a private right of action to file in federal court. But in that type of case, the Department of Labor also will investigate and consider filing as well. But in that type of case, those cases are, if someone complained, for example, they weren't receiving their minimum wage, and they were retaliated against. They filed a complaint with the Department of Labor. The Department of Labor did an investigation. That person cooperated, and then they were terminated. And the Department of Labor will do an investigation. That person may have a private right of action. The bottom line is, that's something to look out for, and that's why the National Labor Relations Board is also working with Wage and Hour, because there could be a basis for a complaint within the board for retaliation under the National Labor Relations Act. There may be protected activity to employees talking about conditions of employment, and in so doing, they're retaliated against and fired or whatever. And so that's the reason why these two agencies, the Wage and Hour Division and the NLRB, want to work together. There's an MOU between OSHA and Wage and Hour to keep in mind. Although they're part of the same department, and they've been collaborating for many years now. They do share information. So if there's a Wage and Hour case that leads to uncover that there's a safety issue in the workplace, and that may lead to various types of cases being investigated, a Wage and Hour case, as well as a safety OSHA case. And then you also have a potential case dealing with not only FLSA retaliation, but also OSHA retaliation under 11C. So you could be dealing with multiple scenarios there all at the same time. The EEOC and Wage and Hour also have a relationship. There's an MOU out there. Again, people being demoted or not paid properly purposely because they've complained in the Wage and Hour context about minimum wage or whatever, or EEOC because of retaliation, etc. They may need to coordinate and work together, and they have been over the years doing much more of that. Although I want to kind of plug in that there has been also a trend within these various agencies to be, maybe not exactly in line with what the previous administration was doing. Although these memorandums of understanding haven't been rescinded, I think federal employees, I could speak, being a former federal employee, they're scared to kind of push the envelope. And so there may be maybe an effort, but these things are still in place, and we expect them at CMC to continue to some level and degree. So let's talk more about the MOU between the NLRB and OSHA. It was signed in October 31st, 2023, and it was in effect for, it's supposed to be in effect for 5 years. So think of it expiring in 2028, October of 2028. It's something still, again, in operation, despite the acting NLRB General Counsel saying that we're going to kind of look into further collaboration with other agencies. There's a memo that was put out by the acting General Counsel that does mention that we're going to be looking into this further, but that's not to say this is not in effect and they're still not collaborating. They want to make sure you're clear on it, but it aims to enhance and coordinate on worker safety and labor rights. So it's really focused on anti-retaliation and whistleblower protections. Here's a statement I think is important to consider. when you're thinking about both of these types of cases, that is, protected activity cases under the National Labor Relations Act and OSHA whistleblower cases. It says the memo says to facilitate interagency cooperation and coordination between the agencies by establishing a process for information sharing and referrals, training, and outreach between the agencies concerning the NLRA, the OSH Act, the OSH Act's anti-retaliation provisions, and any current and future statutory protections which OSHA is charged with enforcing, including various whistleblower provisions. So it's all encompassing to work together in all those respects. And we have a link to the memorandum of understanding directly on this slide. But I want to also be clear that previous memos of understanding were between the NLRB and OSHA were not as robust as the current one. And all those are rescinded. I'm going to talk a little bit later about the differences, but first let's highlight some important key provisions. So we have information sharing and referrals. That I think that's something that has always been there to some level and degree, but they've added a further important context here, and that is upon request or initiative of complaint data. So we're dealing with is OSHA sharing with NLRB the same kind of information that it would need for its investigation that overlaps with the NLRB's investigation. So you got two agencies investigating, finding information that maybe one agency wasn't able to uncover because it doesn't have the same expertise. Maybe one in the National Labor Relations Board is more focused on union activity, but that's not to say union activity is the only thing they're looking at. They're also looking at, again, protected activity. And so, two employees conferring very well in and of itself may be a basis to evaluate whether it's protected activity that could be, that these two employees were retaliated against down the line. Again, all they have to be talking about is conditions of employment for it to be under the NLRB's jurisdiction. And in the same vein, we're talking about conditions on the safety front or cooperating with an investigation with OSHA. All that's related and on the same kind of playing field for these two agencies to find information. And I know from personal experience, OSHA is good at finding information in certain contexts than the NLRB is. And so that's where this comes into play. You may have more cooperation with unions in the National Labor Relations Board than with OSHA. And so they'll find out more information, and that information could be unilaterally requested by the agency that's investigating either the whistleblower in the whistleblower context or the National Labor Relations protected activity context. So, bear that in mind. So ultimately, what we're dealing with here is that kind of these types of measures, these relationships, these memorandums of understanding, which outline the activities of these two agencies and the collaboration of them, increase the likelihood that employers like you are going to be investigated by more than one agency when there's a complaint in one agency or after there's a complaint in one agency. And they're also, again, working together to, not just share information, but, investigate the cases effectively. A lot of times right now, what we're dealing with is OSHA, as well as other agencies, are limited in resources. I will tell you from kind of firsthand discussions with certain former colleagues of mine that they haven't had it worse when it comes to the amount of investigators versus the cases out there and the resource limitations. And so this joint coordinated investigation effort that this memorandum puts together is more critical and crucial than it ever was because of the limited resources. So when they can, they're going to work together. There's also a lot of cross training and outreach because there's not a lot of understanding of what each agency does. So employees have to be better versed in that in the federal government, and that's what they're doing under this memorandum of understanding. They also have, kind of a drive to do more outreach together so they could coordinate their communications to, people that are in the workplace. So they know their rights more effectively. And also a very important component here, this memorandum, is that these agencies are going to be better kind of equipped to handle and work with the state plans. So there's a lot of OSHA state plans. So these, I don't know if you're aware, but certain states have opted to have their own OSHA enforcement. And so under their own state enforcement mechanisms. And so as long as they're, meeting the standards of the federal government, they're able to do that and, collect their own fines and investigate their own cases, and not have the feds, go in and do what typically they do in OSHA federal jurisdictions, which is investigate cases. So the state will do it instead. And this, sometimes information gets lost in that context. So this MOU is designed to help better integrate with the state plans, so that the state plans are, able to help facilitate these investigations, and the feds are there to help as well. So what's new in the 2023 October Memorandum of Understanding versus the prior MOUs? As I said, it covers more. Now it's more focused on not just, the basics of retaliation, but all the OSHA whistleblower. It enumerates all of them as important. Not just, again, OSHA 11C. It expands the sharing authority. It could ask for information on its own initiative, and not just upon a request. Again, we're coordinating more, and they're integrating and educating not just each other, but also the public to better understand, and the states to better understand how to work together in this context. So this is what we suggest you think about doing. Of course, expect overlapping agency visits and the potential for expanded investigations. You need to train, not just EHS and HR, but you need to train your employees, especially the supervisors, on both, the 11C protections as well as the NLRA protections and the potential enforcement that goes along with it. You need to be prepared for no notice before an interagency decides to share the information from your investigation. So assume if OSHA gets the information, that NLRB is going to get it. And so, what I think the most important thing to start doing is, and we work with a lot of big clients that have their own divisions. We have health, safety, environmental, and council, and then we have labor relations council, and sometimes they interact, of course, but not always. This makes it so you need to interact more, because the labor relations issues are going to be intertwined with the OSHA safety issues. And so you got to think about that and try to find a way to integrate your programming together, so to be ready for this kind of potential joint investigation. And finally, establish internal protocols for handling both these types of cases together. So training your employees so that they understand exactly the type of protocols to and how to respond to OSHA and how to respond to NRB, et cetera, or who to contact internally, so that you put your best foot forward. And now I'm going to turn it back to Lindsay to focus more on the types of things you need to think about to be strategically, some recommendations to avoid retaliation and whistleblower claims.
Before I jump into this, I did just want to add to what Mark was sharing about, the agencies sort of working together. I have had a couple cases now where they started off as a Section 11C whistleblower complaint, and then subsequently we received notification from the EEOC that a complaint had been filed, and then also notification that an unfair labor charge had been filed with the National Labor Relations Board. So this is happening. The agencies are coordinating in certain circumstances. They are sharing information where they detect that there could be a potential issue with discrimination that is being referred to the EEOC, or the investigator is having conversations with the complainant and actually sharing with them, hey, I see some issues here that might fall under Title VII. You might consider also filing with the EEOC. So I just wanted to share my personal experience that we have seen this coordination. We've seen the effect of this coordination. And even where it ultimately is the case that each agency determines that there's no basis for the complaint, you're still going through each individual investigation process, and there's some information sharing, but it certainly still makes all of it a much greater burden on the employer in responding to the complaint, where you might be receiving multiple complaints because of the agency's coordination. So we're going to close out here with just some suggestions and recommendations of steps that employers can take to try to avoid these types of retaliation and whistleblower complaints being filed with federal agencies. The first is to maintain a clear complaint policy. And I addressed this a little bit in prior discussion about, formal complaints versus informal complaints. But it is really important to have a policy in place so that employees feel like they can bring these types of concerns to the employer's attention and that those concerns will be addressed when they're brought to the employer's attention. So the first piece of this is establishing a complaint policy or policies, and sharing those policies with the employees. It might be, that the process is described in the employee handbook, and as part of the onboarding process, new employees given a copy of the employee handbook. That provision is in there. They sign the employee handbook. It is really helpful to have training that also incorporates the policy so that the employer can show that the employee was aware of the complaint policy if it's necessary to do so later on. But then the other way, if it is more of a standalone policy, is to give a copy of that policy to the employee and have them sign to indicate that it has been received and reviewed. The policy should be written, and it should be written in clear, simple language so that it's easy to understand. You want to make sure that any employee can understand how they can raise complaints to the employer so that they do raise these complaints internally, as opposed to just feeling like they need to go out to a third-party agency to have the complaint addressed. You should clarify what behaviors and issues should be reported, how that complaint should be made, and the actual investigation process. So the written policy should include, what is covered, what should the employee raise complaints about. It could be very broad, that any concern that they have should be, raised through this particular complaint process, but certainly in the context of a non-discrimination policy or anti-retaliation policy, it's important to specify that particular acts that could be seen as harassment or sexual harassment or discriminatory, that those should be raised through this particular complaint system. This is how you do it, and it will be investigated. So if you raise a concern, it's not going to just fall on deaf ears. It will be investigated, and here's the process that we use. The policy should also make clear that investigations and follow-up will be prompt. And then finally, it should include clear protection from retaliation for participating in the process. So you want to let employees know that if they do raise these concerns internally, again, they're going to be protected from any sort of retaliatory action from anyone at the company because they raised that concern. Training is absolutely essential in not only implementing these policies effectively, but also ensuring that the manner in which an informal complaint or concern is addressed is done in a way that avoids any appearance of retaliation. So employees should be trained on the complaint procedure. I referenced that already, but it is helpful when you're doing anti-discrimination training or anti-harassment training. This can be incorporated as part of that. Here's the complaint procedure. If you have experienced any of these things, these are the steps that you can take to raise the complaint internally and have it investigated by the employer. Direct supervisors and managers should also be trained on retaliation and how to work with and manage protected employees. So those employees that have engaged in protected activity, how should a manager interact with them to avoid any appearance of potential retaliation? Because like we said, earlier in the training, an adverse employment action is broader than just termination, suspension, decrease in wages. It can include threats. It can include, changes to hours. So managers really need to be aware that their actions can be perceived in a certain way by an employee. So how do we work with this employee? How do we manage, relations with them effectively to avoid any of that, particularly after they have engaged in protected activity? And then the last part here is what specifically managers and supervisors should receive training on. And that includes how to respond to complaints. So again, those informal situations where an employee is just coming up to them, on the floor and saying, here's a concern that I have about safety. How should they respond to that complaint in the moment? What should they do with that complaint? The types of actions that are considered adverse, the perception of retaliation, and that issue of proximity. If, they complain to you informally about a safety concern and then a week later you change their hours, that could be potentially a basis for them to believe that they have been retaliated against, even if there is a legitimate reason for that change. Effectively communicating what a legitimate employment action is and how that's established, and then how to document that the employment action is legitimate. How do you show through documentation that, if it's employee performance, for instance, that's the reason for the adverse action? Do we have prior disciplines? Do we have prior written counselings? Pulling that documentation together in advance and knowing what that documentation is a really important part of the process and something that supervisors and managers should be trained on. And then that, I think, leads really well into this next point about developing and maintaining documentation. So prior to, and then when an adverse action is actually implemented, it's really important to document each step of the process. Where you have an employee who is having a lot of absences, are they receiving that notice each time that they have an unexcused absence? Is that being put into their personnel file so that, at the fifth absence, it's all been documented? We can just go to that to say the policy says after 5 absences, you are suspended for a week. And so we're going to implement that pursuant to our policy. And here's all the documentation to support that. It's helpful to, in that documentation, detail the decision-making process in accordance with policies and procedures. So these things should be already laid out in your policies, particularly, with the absence situation I just talked about. If we're asserting that they're being disciplined for a violation of a policy or procedure, that those steps are being taken in accordance with the process that procedure lays out or that policy lays out to actually implement the discipline against the employee. And then again, documenting all training and instruction that's provided on applicable policies and procedures. So again, if the employee is being disciplined or terminated for a violation of a particular rule or expectation, it's helpful to be able to go back to their training and say, look, they knew what the policy was or what the rule was, and they didn't follow it. And these are the repercussions as laid out in that policy or procedure. It's also helpful to keep notes of employee interviews if there's an investigation that leads to an adverse employment action, that there's notes in a file of that investigation as to the discussions that were had with the employee, to record the reasons for the determination or outcome. That sometimes is already included in the disciplinary notice that they receive. But that is something that should also be documented in some way, shape, or form, the justification for the adverse employment action. Providing written certification of any follow-up actions, and then finally apprising a complainant of findings and resolutions. So as part of an investigation process, making sure that the complainant does know the investigation was conducted and, some general understanding that action was taken as a result, or a determination was made that there wasn't any wrongdoing, and so no action was taken as a result. And then finally, and really, really importantly, employers need to be consistent in implementing policies and procedures. The biggest thing that I think, get questions on, or one of the biggest things we get questions on as part of these investigations is, I want to see, if an employee was terminated for a violation of a particular rule, and they're asserting that no, that termination is actually because they engaged in protected activity, the investigator is going to ask you, can you show me other examples of employees who violated this same rule and were also terminated? And if they weren't terminated, can you show me why they weren't terminated? Because that similarly situated employee analysis is going to come into play in determining whether there is a causal connection or a reason to believe reasonable cause to believe that there is a connection between the protected activity and the adverse action. So it's really important that we are able to show, or that employers are able to show, that the actions that they're taking related to this particular employee are consistent with what they've done in the past for similar policy violations, where there are repeated absences, things like that. And so, again, the most effective way to do that is through documentation. And that's why documentation, again, would come into play on that. And ultimately, an employer should be able to show that a similarly situated employee outside of the complainant's protected category, which in this case, in cases of retaliation and whistleblower, those employees who haven't engaged in protected activity as alleged by the complainant, that they're treated in the same way. And if they're not treated in the same way, that we have a justification for that. And then the last few slides here just show the upcoming webinars that we have for the labor and employment practice, as well as the OSHA practice. Our blogs are a great resource on many different issues within the labor and employment and OSHA context, as well as our amazing Cal OSHA and MSHA blogs. So those are definitely a good resource if you have questions on these issues. And we have also posted many times about whistleblower complaints and retaliation complaints. So that could be a good resource on this issue as well. And then we also do have some master classes that we're currently offering, and there's information here as well as on our website on those. And coming up in October, we are having our Cal OSHA and California Labor and Employment Law Summit. So if you are in the area or able to get to the area, we certainly invite you to attend.
Yeah, so we have a few questions. I think in the complaint policy, is the employer allowed to establish a chain of command for issuing a complaint or concern? Now, Lindsay, I know you talked about that. You want to handle that, or?
Sure. I mean, you can certainly establish who an employee should go to make a complaint. Whether it's their direct supervisor, or if they're not able to go to their direct supervisor, human resources personnel. It is really helpful in a complaint policy to have more than one avenue, because, if the employee is complaining because they have concerns with how their direct supervisor is treating them, then if the policy only says go to your direct supervisor with complaints, that's not going to be very helpful to them. And they might feel like they don't really have another resource if their direct supervisor is the one they want to complain about. So it is really helpful in a complaint policy to have various avenues that an employee can take, whether it's, go to your direct supervisor. You can also go to HR. Some employers will designate certain higher level managers that an employee can contact. Some employers also use like an anonymous either phone line or email address to which an employee can submit a complaint. So it's really good to have several avenues. And yes, in a complaint policy, you can certainly lay out the expectations for where an employee can go to make a formal complaint or, raise a concern to a representative of the company.
Yeah, another question we had was we recently received a notice from OSHA that an employee had filed an 11C retaliation complaint against the company back in April, and that OSHA was dismissing the complaint. We did not receive notice of the complaint from OSHA when it was originally filed. Is that normal, typical? My response is not normal, typical. That said, it must have been a complaint that had clearly been an issue. There was an issue with its likely the statute of limitations, and that the OSHA didn't find a need to contact the employer yourself because it knew the case wouldn't be able to proceed. So those types of situations, especially nowadays, again, OSHA is not able to it doesn't have the resources that it used to have. And so it's limited, and it needs to make strategic decisions, especially considering it had probably a strong basis to say it didn't have any merit for whatever technical reason or legitimate one.
All right. Well, thank you everyone for joining us today. And we hope you found this informative and helpful, and we look forward to seeing you on webinars in the future.
Thanks, everybody.